Hello, everyone. Good afternoon. I'm Michelle Waslin, the Assistant Director of the Immigration History Research Center at the University of Minnesota. Welcome to today's webinar on Birthright Citizenship. Thank you so much for joining us today. Today is September 17th, and that is Citizenship Day in the United States. So thank you so much for spending part of your day with us today. This webinar is part of the IHRC's new History of the Present webinar series, which is designed to give historical context for a contemporary immigration issue. So as you know, birthright citizenship has been making news again recently, with the president signing an executive order intended to restrict birthright citizenship, and then subsequent legal challenges to that order. Now, for a long time, there have been arguments against birthright citizenship, and people have suggested that the Constitution does not guarantee citizenship to certain persons born in the US. And unfortunately, today, some of those arguments, which were once seen as extreme, are gaining traction. So today, our experts will share the history of birthright citizenship, explain why it is included in the US Constitution, how it has impacted different groups in the US, and what any changes to birthright citizenship could mean. I want to extend many thanks to our co-sponsors at the Department of History at the University of Minnesota. I'd also like to acknowledge that the University of Minnesota Twin Cities campus is physically located on Dakota land. Today, many Indigenous people, including Dakota and Ojibwe from throughout the state, call the Twin Cities home, and the IHRC acknowledges that the migration of immigrants and refugees to the U.S. has been part of settler colonial practices that displaced and dispossessed Indigenous peoples. And the study of immigration must acknowledge these intersections, consequences, and legacies. Now, just a little housekeeping that you're familiar with. This webinar is being recorded. The question and answer portion will happen in the Q&A function on your screen. You can submit questions at any time during the presentation. We will turn to audience questions at the end of the program. You can choose to submit questions anonymously if you don't want your name to be mentioned when the question is posted. Now I will introduce today's moderator. William Jones is professor and associate chair in the Department of History at the University of Minnesota and president of the UMN Twin Cities chapter of the American Association of University Professors. He focuses on the 20th century United States with particular interests in the relationships between race and class. He has published books on African American industrial workers in the Jim Crow South and the March on Washington for Jobs and Freedom in 1963, and has written for the New York Times, the Washington Post, and other publications. Will is currently writing a history of essential work. Will.
Thanks, Michelle. Good afternoon. In many respects, the roots of birthright citizenship stretch back to Fort Snelling, just a few miles from the University of Minnesota, where in 1837, Dred and Harriet Scott met and began a family in a nation where they had been born, but that denied them the most basic rights to have rights. That denial was affirmed in the US Supreme Court's 1857 ruling that the Scots and all Black people had no rights, quote, which the white man was bound to respect, unquote. It was also front of mind for those who pushed for the Civil Rights Act of 1866 and the 14th Amendment in 1868. By then, Fort Snelling had also become associated with the exclusion of American Indians from those protections, as it was the site of a concentration camp where nearly 2,000 Dakota people were incarcerated before their expulsion to the Dakota Territories in 1863. So it is fitting that the University of Minnesota is the host of today's discussion of birthright citizenship, its history and its meaning today. And I'm honored to moderate this discussion and to introduce the distinguished members of our panel. Anna O'Law is the Herbert Kurz Chair in Constitutional Rights in the Department of Politics at the City University of New York, Brooklyn College. Her publications appear in political science, history, and law journals and investigate the interaction between law, legal institutions, politics, and history. Her second book, The Migration Origins of American Citizenship, African Americans, Native Americans, and Immigrants, a reinterpretation of U.S. migration policy, history, and law, will be out on Oxford University Press in late spring 2026. She teaches and researches in U.S. constitutional law, federal courts, U.S. immigration policy history, federalism, American political development, and race and ethnicity. Anna recently published an op-ed titled "History Shows Why Birthright Citizenship is So Important," which explains why birthright citizenship was and is so important in determining who was included in the political community. Stephen Kantrowitz is Linda and Stanley Scher Professor of History at the University of Wisconsin-Madison, where he has taught since 1995. He received his PhD from Princeton University. His research focuses on race, politics, and native settler interaction, primarily in the 19th century United States. He is author of 3 books, Ben Tillman and the Reconstruction of White Supremacy, which won several scholarly awards and was a New York Times Book Review notable book. More Than Freedom, Fighting for Black Citizenship in a White Republic, 1829 to 1889, which was a finalist for the Lincoln Prize and the Frederick Douglass Prize. And most recently, Citizens of a Stolen Land, a Ho-Chunk history of the 19th century United States. He has been a fellow at the Radcliffe Institute for Advanced Study, the Fulbright Distinguished Professor of American Studies at the University of Southern Denmark, and an Organization of American Historians Distinguished Lecturer. Carol Nackenoff is the Richter Professor of Political Science Emerita at Swarthmore College, where she taught constitutional law and American politics. She is also co-author of American by Birth, Won Kim Ark, and The Battle for Citizenship. She continues to write and speak about birthright citizenship and the likely implications of President Trump's Executive Order 14160 if it is implemented in whole or in part. Carol is author of The Fictional Republic and co-author of several books, State Building from the Margins, Stating the Family, and Jane Addams and the Practice of Democracy. Recent publications have appeared in the Journal of Women, Politics and Policy, Maryland Law Review, Studies in American Political Development, The Conversation, and in the Progressives Century, Quakers and Native Americans. She is currently examining the role that organized women played in pressing new definitions of public work on the American state in the late 19th and early 20th centuries. Cecilia Marquez is the Hunt Family Assistant Professor in History at Duke University. Her research focuses on the history of Latino people in the U.S. South. Dr. Marquez writes and teaches about the formation of Latino identity, Latino social movements, and the importance of region in shaping Latino identity. Her work has been supported by the Mellon Foundation, the Woodrow Wilson Foundation, and the Smithsonian National Museum of American History. Her new book, Making the Latino South, retells the history of the American South with Latinos at the center and reveals that to be Latino in the South was unlike being Latino anywhere else in the nation. In this book, Marquez studies challenges commonly held beliefs about the origins of Latino identity and the power of region in shaping race. So we'll begin with Anna.
Thanks, everyone, for joining us this evening. Happy to be with everyone today. Today, the biggest fights about immigration policy and law are constitutional fights. They're less over policy, but there are big constitutional questions, including over birthright citizenship. The topic that I wanted to address with my 10 minutes is to talk about why do we have birthright citizenship in the 14th Amendment, and what were the framers' intent when they put birthright citizenship in the 14th Amendment. So political theorist Hannah Arendt, who was writing in the 20th century, described formal citizenship as the right to have rights. And the opposite of that, the implications of not having legal citizenship, is quite profound. It was back then, at the passage of the Reconstruction Amendments, and it is today. As a reminder, last week's statistics from ICE, they currently have 58,766 people in detention right now, of which only 300 have criminal records. These people have mostly violated U.S. immigration law and not criminal law. That is, many of them have not had trials, no due process, and they may be shipped and deported. Deported is not even the word. They may be sent or exiled to another country where they're not even from. All that because they lack US citizenship. So the goal of the Reconstruction Amendments passed after the Civil War, the 13th Amendment abolishing slavery, the 14th Amendment, birthright citizenship, equal protection, the 15th Amendment, universal male suffrage, those were all to fight against and to prevent state discrimination against Black people after slavery was abolished. And so the 14th Amendment in particular did that in several ways. First, the 14th Amendment, by creating birthright citizenship, defined national citizenship for the first time and defined how you obtain it. They did so because before the Civil War, the citizenship of free Black people was unclear. Many states, northeastern states like Massachusetts, allowed Black men to vote and to serve jury duty. Other states gave free Black people a subset of those political rights as well, and other slave states gave free Black people zero rights. So it was not clear what was the citizenship of free Black people. The US State Department would not issue passports when they asked for it, saying they were not national citizens. So the 14th Amendment clarifies that all Black people and anyone born on US soil, with very narrow exceptions, are US citizens. The other thing the amendment does is to place US national citizenship above state citizenship in importance because it wasn't clear. So what happens if state citizenship rights conflict with your national citizenship? Well, the 14th Amendment Birthright Clause makes that clear. The framers of the 14th Amendment went through the Article 5 ratification process to change the Constitution so that future Supreme Courts, future presidents, and Congresses couldn't easily overturn and get rid of birthright citizenship. The reasons for birthright citizenship were foremost to address the unclear status and citizenship of African Americans. It was required because there were practical consequences of the lack of clarity of the legal citizenship of Black people. There was a group called the American Colonization Society that reached its popularity in the 1830s. And it was a private group that had a lot of prominent politicians that supported it, and they advocated for to ship free Black people away from the U.S., to send them to parts of Africa, to parts of Central America, to countries they had never seen before, because they were rejecting the idea of a multiracial democracy. So before the Birthright Citizenship Clause made clear that Black people are citizens of the US, they worried about whether the American Colonization Society movement, whether those colonization programs, were they going to be voluntary or not, because their citizenship wasn't clear. Before the Civil War, the colonies and the states exclusively ran migration policy, including deporting people, including excluding people. There was a patchwork of state level restrictions on interstate and international travel, and burdensome impositions of laws that had to be met if free Black people wanted to simply live in a particular state. So before there was birthright citizenship made clear, those laws existed, and the freedom of movement and settlement was simply not enjoyed by free Black people or enslaved people. Before the Reconstruction Amendments, there was no concept of individual rights, due process, or equal protection. The 14th Amendment creates all of those things, and it creates individual rights for the first time. If you read Section 1 of the 14th Amendment, it not only extends equal protection and due process to citizens, but also to the language is all persons. And that encompasses a larger group of people than just the people who are born here. It includes Chinese immigrants that Carol Nackenoff will talk about. So what's the takeaways of this history? It's very clear that birthright citizenship in the 14th Amendment, Section 1, was to clarify the citizenship status of African Americans and to make clear that they are US citizens. The Birthright Citizenship Clause in the 19th century was not about illegals. It was not about the loyalty of immigrant parents and about whether they were subject to the jurisdiction, which Steve Kantrowitz is going to talk about next. By the administration bringing in these spurious arguments, they are made that this is to project present day political priorities backwards in time, where the immigration system was totally different and the sense of political priorities were totally different. So let me hand this off to Steve. Thank you.
Thank you, Anna, and thank you to the Center for inviting me to do this. And I'll just get right to my remarks, which concern why and how Native Americans were generally excluded from birthright citizenship under the 14th Amendment, and what the implications of this are for present debates. And my key point is this: the citizenship status of Native Americans, people and communities, has historically followed from their national status, a unique status recognized by the Supreme Court and other authorities across the 19th century, before the 14th Amendment, during its formulation, and after its ratification. This changed in some important respects with the Indian Citizenship Act in 1924, but since it's the 19th century debates and precedents that are at issue in the present executive order and cases around it, this is where I'll focus my remarks. First, we need to think about the special quality of tribal sovereignty, which in American constitutional law is distinct both from other classes of people who were born under the criminal and civil jurisdiction of the United States, and of other classes of people migrating into the territory of the United States from nations other than tribal nations. In the 1830s, the Supreme Court made its best known articulation of this special status by describing Native nations as domestic dependent nations, kind of paradoxical formulation, in but not of the United States, analogized by the court to the relationship of a ward to a guardian. But the court said more than this. Native people under tribal government who are in a treaty relationship with the United States stand outside the bounds of the body politic, but not in precisely the same way as any other group of people. Chief Justice Marshall in Cherokee Nation versus Georgia called the relationship between Indians and the United States unlike that of any other two people in existence. The only other group of people in this category of persons within the jurisdictional geographic boundaries of the United States, but not subject to its jurisdiction, were foreign diplomats and their families, who, like Native people under tribal government, were held to be immune from U.S. jurisdiction. U.S. policies around tribal sovereignty are shaped by the fundamental imperative of U.S. Indian policy in the 18th and 19th century, and that is to claim whatever native lands the U.S. and its settlers wanted with the least possible risk and the least possible cost. The U.S., states, squatters, they all want Native people's land. And colonial and European assumption is that Native nations' title to land is not the same as theirs, that Native people inhabit and use, but do not really own that, and therefore European powers have the right to claim, to treat, and to make that land their own. This is the doctrine of discovery, which the Marshall Court in the 1830s essentially says is also U.S. constitutional doctrine. Now, the U.S. and its citizens do make war in order to claim that land, but they're reluctant to rely on war alone. It's expensive, it's dangerous, it's uncertain, sometimes it's morally unsettling. So the solution is treaties, which are acts of diplomacy under Article 2, the supreme law of the land, but they're also instruments of coercion, and increasingly so across the 19th century. In 1832, when the federal government imposes a treaty of cession upon the Ho-Chunk in the aftermath of the Black Hawk War, the treaty commissioners just frankly write, this is on the blended grounds of conquest and contract. And that kind of encapsulates it perfectly. As with so much pertaining to Indian law and Indian policy, treaties are fundamentally an end-oriented policy, and the end is the right of the U.S. to take whatever native land it wants, whenever it wants to take it. This has enormous consequences for native nations and their sovereignty, which are, of course, not only land, but people. The United States wants the right to take the land, but it doesn't want to be forced thereby to accept the populations on that land. And of course, this explains the policies of ethnic cleansing that we've called removal. It also explains a welter of additional policies about the status of Native people themselves in relation to the United States, including, even before the Civil War, the possibility of Native American citizenship in the United States. For example, under the Indian Removal Act of 1830, which we think of as the enabling act for the banishment of removal, Native people could avoid that banishment by submitting themselves to the jurisdiction of the states in which they lived and losing federal recognition of their national claims. And some did this. In Mississippi, for example. But remember, in the 1820s and 30s, there was no presumption of equal protection of the laws, and this was a pretty bad deal. But there were other federal policies, and over the next decade, several Indian nations take up citizenship by law or by treaty, including the Stockbridge-Munsee and the Brothertown in Wisconsin, the Wyandot in Kansas. They often do so simply to forestall their total dispossession. It's the best of terrible options as they perceive it, and it very frequently has the result of them losing the land that they had intended to protect in that way. Nevertheless, by the late 1870s, Congress counts roughly 13,000 Native Americans who have become U.S. citizens by law or treaty, one kind or another. Small minority, but nonetheless an interesting group of people to think about. With all of this in mind, how were Native Americans excluded from the 14th Amendment's revolutionary transformation of citizenship, which Anna just spoke about? Now, the avowed purpose of the first section of the 14th Amendment, the revolution in American life, was to establish the constitutional status of African Americans as U.S. citizens. But as Congress debated this principle, it embraced a more universal view of birthright citizenship and a more universal language of citizenship. Subject to all persons born or naturalized and subject to the jurisdiction. There was considerable debate about this in 1866 in Congress. Opponents of universal birthright citizenship argued that Chinese immigrants and their children, Roma immigrants and their children were culturally inferior and unfit for citizenship and therefore should not, could not be encompassed, but would be by this language. They also argued that the children of non-naturalized immigrants were not birthright citizens, which brought scoffing rebukes from colleagues who understood that countless eligible immigrants had never naturalized, but that their children, German American children, for example, in Pennsylvania, had always been presumptively citizens. So that argument is sort of cast aside, as is the argument about Chinese and Roma children and their citizenship. The framers of the 14th Amendment are very clear. Yes, it includes them. Birthright citizenship will include them, even if, like the Chinese, they are not eligible for naturalization and citizenship themselves as immigrants. So these arguments failed against the universal principle of birthright citizenship. But this is the critical final point. The framers were unanimous that their language of birthright should exclude Native people under tribal government. And the phrase that they selected for this purpose was subject to the jurisdiction. All persons within the territory of the United States, they firmly believed, were subject to its civil and criminal jurisdiction, with two meaningful exceptions: diplomats and their families, and Indians under tribal government. The purpose and intent of the formulation subject to the jurisdiction was simply to exclude Native Americans' children from the rule of birthright citizenship. And Congress proceeded this way because this was the common presumption by the 1860s, as it had been for generations, that Native Americans stood in a fundamentally different relationship, a unique relationship, remember, to U.S. sovereignty and therefore to U.S. citizenship, a relationship rooted in the imperatives of land taking. Now, there was some continuing doubt about the phrase subject to the jurisdiction. And in the 1866 congressional debate, one senator warned his colleagues that, hey, the United States asserts the right to take whatever Indian land it wants. And so all of the land and all the people on it are in an important sense subject to the jurisdiction of the United States. It's a powerful argument, but it was rejected by the Senate as the meaning of that phrase. But by 1870, after the ratification, there'd been enough turnover in the Senate that a newcomer from Arkansas, I think, comes and asks for clarification. Did the 14th Amendment make citizens of all the Native Americans in the country? And the Senate actually convenes a committee to figure out whether that's what they did by accident. And they rule finally, no, that's not, we meant what we said, subject to the jurisdiction is intended to exclude Native Americans and Native Americans alone. Now, today, opponents of birthright citizenship have seized on particular words and phrases in the 1866 debates, and in particular, the congressional framers' use of the word allegiance has been put forward as a way to argue that people who do not subjectively perceive themselves as loyal to the United States, who hold another citizenship, not U.S. citizenship, are not therefore subject to the jurisdiction. But this is an error rooted in a misconstruction of the meanings that congressmen ascribed to that word in 1866. Scholars, such as most recently Greg Ablavsky and Bethany Berger, have shown that allegiance was a term of art. It meant the obligations persons owed to a sovereign when within its protection, not whether they were personally loyal to the sovereign. And Ablavsky and Berger put it this way: allegiance depended not on individual loyalties, but on the scope of the sovereign's authority. And once more, this distinguished all manner of immigrants, whether or not they were eligible for naturalization, from Native Americans who stood in a separate, unique category, whom the United States had decided were constitutionally uniquely distinct. Now, the Supreme Court reaffirmed this meaning of jurisdiction in 1884 in a case called Elk v. Wilkins, which is the case of a Ho-Chunk man living in Omaha whose lawyers asserted that he had severed his tribal ties and become a civilized person and submitted himself to the jurisdiction of the United States, and therefore he could register to vote. And to make the long story very short, the Supreme Court rejected this claim. In its ruling, it emphasized the unique status, again, of tribes as distinct political communities and the resulting limits that this placed on the United States jurisdiction over Native people. And Elk, they said, could not detribalize himself. Only the federal government could do that by law or by a treaty. And in light of this status, the court said, tribal members, though in a geographical sense born in the United States, are no more born in the United States and subject to the jurisdiction thereof than, get these two categories, the children of subjects of any foreign government born within the domain of that government, so aliens born abroad, and the children born within the United States of ambassadors and other public ministers of foreign nations, diplomats. So those are the only two categories that are analogous in the court's view to in terms of exclusion. I could say more about the government's arguments in defense of the EO and especially about their misconstruction of the history of Indian law and jurisprudence, but if we're to take history at all seriously, those arguments have to be seen as charitably bad lawyering or less charitably made in bad faith. Thanks. I'll hand it over to Carol now.
Hello, everybody, and thank you for inviting me today. I want to talk mostly about the case that's the major precedent for the battle that's going on right now, which is U.S. versus Wong Kim Ark from 1898. This is the major birthright citizenship case that people are either wanting to chuck out or reinterpret. Wong Kim Ark was born in San Francisco's Chinatown in 1873. He was born above the butcher and provision shop that his parents ran. His parents had come to California around 1859, and Wong's father was classified as a merchant. There were no restrictions on the Wong parents' entry into the United States, and they resided here legally. Pat, if you want to put up the one slide, the cartoon, with increasing Chinese immigration came increasing hostility toward the Chinese, along with anti-Chinese violence on the West Coast. Some labor groups claimed the Chinese were willing to work for low wages and were taking their jobs. So there were riots, destruction of property, expulsions, and murders of Chinese in a number of Western cities. This cartoon by George Frederick Keller from late 1881, entitled A Statue for Our Harbor, at a time when the Statue of Liberty's right arm and torch was being exhibited on the East Coast, captures some of this virulent hostility. Immorality, filth, diseases, ruin to white labor are printed on rays above the Chinaman's head and queue. The Chinese Exclusion Act, and you can take that down now, please, Pat. The 1882 Chinese Exclusion Act barred laborers from entering the U.S. for 10 years, a ban that was renewed. As a merchant, Wong Kim Ark's father could come and go. But his son, Kim Ark, was classified as a laborer. He was a cook. He traveled with family members to China in 1889 to get married. Ever since the Page Act of 1875, which is the first Immigration Restriction Act, it had been very difficult for unattached Chinese women to come to the United States because they were assumed to be prostitutes or that they were being groomed for prostitution. So the Chinese men living in the United States often took the long journey to China to form families. Wong Kim Ark's first son was conceived on this trip, and he returned to the U.S. basically without incident. His growing family remained in China, their ancestral village in Guangdong province, which was an area from which many Chinese migrated to the U.S. Could you put up the next slide, please? Wong Kim Ark went to China again in 1894 to see his family, and he sired another son. When leaving the U.S., he had to file what was called an application of alleged American-born citizen of the Chinese race for pre-investigation of status and get a return certificate before departure. And he had to file such a certificate every time he went, even after his Supreme Court victory. In 1894, he would appear before a notary public in San Francisco with a photograph and a typed application, signed a statement, produced 3 witnesses who also signed, claiming that Wong Kim Ark was well known to them. It was on his return in 1895 that things went sideways. He was detained when he attempted to land in San Francisco. Anti-immigrant forces were determined to have a test case and thought this was a good one. Government officials agreed that Wong Kim Ark was born in the United States and had always maintained an address in the U.S. But the government officials claimed that his minimal education and political affiliation as a subject of the Emperor of China overcame any claim to citizenship. Wang was held offshore on one steamship, then another, as the habeas corpus appeal dragged on. He was allowed to land only in January 1896, when a federal judge from the Northern District of California held that he was indeed a U.S. citizen. The government appealed to the Supreme Court. Wang Qimmark was a man of small means, but he was represented by very able and prominent lawyers, thanks to the Chinese six companies who kept excellent lawyers on retainer to deal with all sorts of litigation involving Chinese businesses and individuals, including many habeas corpus cases that came before the federal courts. Can you move to the next slide, please? When the Supreme Court heard the case, the writing fell to Justice Horace Gray, who had also penned the majority opinion in Elk versus Wilkins that Steve was just talking about. For him and for members of the Wang Qimmark majority, these two cases were compatible and logically consistent. The 6-2 majority embraced the principle of jus soli that had been articulated in a number of antebellum cases. The notion that citizenship follows that of the sovereign over the territory where one was born, along with its common law exceptions, go back to a 1608 case in England when King James VI of Scotland inherited the throne of England after Queen Elizabeth died and became James I. As the nations became effectively united, were James's Scottish subjects now subject of the English crown? The court's answer was yes. The principle of jus soli was incorporated into U.S. jurisprudence. This is common law. American colonists were considered citizens of Great Britain and subjects of the British crown. Steve mentioned the exceptions, the common law exceptions. I'll add one. Ambassadors and foreign consuls. They were loyal to their home sovereign, and their children, if they were born in the U.S., were not U.S. citizens. Invading or occupying military forces owe allegiance to another nation. Their children, if born in the U.S., were not U.S. citizens. The nationality of babies born on a U.S. registered ship in international waters also follows the nationality of their parents. And we talked a little bit about the Native American situation. While the 1924 Indian Citizenship Act granted birthright citizenship to Native Americans born within the borders of the U.S., in the late 19th century, the Native Americans were considered to owe allegiance to their tribal governments and were not fully subject to the political jurisdiction of the U.S. Now, this was a time of flux. Reformers wanted to more fully extend the reach of U.S. law to Native Americans as a way to civilize them, and the Dawes Act of 1887, 3 years after the Elk decision, was designed in part to provide a path to citizenship to Native Americans who accepted their land allotments, lived there, worked on them, and pursued the habits of civilized life. It was also designed to eventually break up tribal governance. The question of when and whether Native Americans became citizens continued to confound many federal and state administrators, in part because of a period of tutelage that the Dawes Act stipulated. But Gray talked about how, in Wang Qimmark, talked about how the Indian tribes were not part of the people of the United States and that they could not throw off their dependence, and they could not put off at their own will their tribal membership without the action or assent of the United States. It is important to understand the language of Justice Gray in the context of talking about Native Americans and not somebody else. So after he went through the exceptions to birthright citizenship in Wang Qimmark, he said, the 14th Amendment in clear words and in manifest intent includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. So the Supreme Court concluded that Wang Qimmark was by birth a citizen of the U.S. And I should point out that this broad reading of birthright citizenship was consistent with the practices and laws of many settler nations. If you look today, you will see that many South American nations still retain some form of birthright citizenship. It was when you were trying to populate the nation, they were trying to populate the nation with, it's true, people that they thought were like them, but they still had expansive grants of birthright citizenship. The court was concerned with the implications of a cabined reading of subject to the jurisdiction, because it would mean that all these immigrants that we acknowledge and liked from England, Scotland, Ireland, Germany, etc., their kids would have to be naturalized, really, if that seemed an unacceptable conclusion. John Eastman, the founding director of the Claremont Institute Center for Constitutional Jurisprudence, who has been weighing in on birthright citizenship challenges since the first Trump administration, argues that Elk v. Wilkins and Wong Kim Ark are not consistent, and that Wong Kim Ark is wrong. Now, this would make Justice Gray and his colleagues just a bunch of muddle-headed justices, and I think that is not correct. Peter Schuck and Roger Smith argued 50 years ago in Citizenship Without Consent that Elk's upshot, that no one could be made a citizen without the nation's consent, is the better principle, and their argument is one that friends of the administration have latched onto now. But let it suffice to reiterate that the case of Native Americans was different. It was an exception to a broad principle of jus soli. In U.S. versus Wong Kim Ark, Justice Fuller dissented. He thought assigning citizenship by place of birth was a feudal practice and was just common law, and the proper rule should be descent. He thought that, Justice Harlan joined him. And this is interesting because Justice Harlan is the author of the famous Plessy versus Ferguson dissent, that there is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. So he argued that the nation had a right to exclude a race that is considered unassimilable and to deport people who were not naturalized or who were barred from naturalization by the Chinese Exclusion Act or even the Naturalization Act of 1870. I should end by saying that even after winning his case, Wong Kim Ark still had to file the same application. If you want to show the next slide, he did so again in 1904. That is the final one, which is fine. In 1931, he applied again, and this was the last time that he left the country at this point. He was no longer able to find work as a cook. His wife was still living, and he apparently died in Guangdong province sometime in the 1930s or early 40s. This understanding of birthright citizenship has been accepted by the court since 1898. There were a few challenges in the 1930s and 40s, especially concerning the citizenship of Japanese, but the court rebuffed these challenges. And so it's not until the 1990s that we again start seeing some rumblings about wanting to revisit birthright citizenship. And now I will turn it over to Cecilia.
Hi, everyone. Good evening. I want to start by thanking Michelle for inviting me to be on this panel and my fellow panelists for all their insightful comments. I've learned a lot already. My charge today was to think in particular about the impact of the attacks on birthright citizenship have on Latino communities. There's some immediate answers rooted in the present moment. We know, for example, that an end to birthright citizenship would disproportionately impact Latinos. According to UCLA's Latino Policy and Politics Institute, of the 5 million children born to non-citizen parents in the United States, 4 million of those are born to Latino parents. Additionally, research shows that punitive immigration legislation, like these recent attacks on birthright citizenship, lead to reduced healthcare utilization, worse birth outcomes, and lower utilization of public safety net programs like SNAP and Medicaid. Further, given that as of January 2025, hospitals are no longer protected areas from immigration, customs, and enforcement, or ICE activity, immigrant populations are even less likely to seek care prior to an emergency. But what I want to talk about today is the long-standing historical gap between legal and social citizenship that has existed for the Latino population in the United States. What I mean is the gap between the promises of citizenship and how that citizenship is actually experienced and what that has to do with labor and exploitation. We might think contemporarily about the recent Supreme Court decision that makes racial profiling legal for the purposes of immigration enforcement. And it perhaps best demonstrates the fragility of certain kinds of protections for Latinos in the United States. So today I want to talk about two moments in Latino history that highlight the fragility of the status of Latinos in the US: the repatriation campaigns of the 1930s and Operation Wetback. But in order to understand how we get there, I need to take us back to 1848. In 1848, at the end of the Mexican-American War, Mexicans living in the ceded Mexican territory, the land that the US had just taken from Mexico at the end of the war, were given a choice. They could remain in what was now the United States and become US citizens, or leave and remain Mexican citizens. Those who stayed began what would become a centuries-long negotiation about the boundaries of citizenship for Mexican Americans and Latinos more broadly. The Treaty of Guadalupe Hidalgo, which ended the war, guaranteed that these newly minted US citizens were to be considered legally white. And yet, this legal whiteness, this legal citizenship that they were guaranteed through this treaty, did not prevent Mexican Americans from experiencing segregation, theft of land, and violence in lands that were formerly Mexico. So let's start with the repatriation campaigns. In the 1910s, unrest on both sides of the US-Mexico border resulted in a spike in migration. In Mexico, the Mexican Revolution raged, and in the US, the entry into World War I resulted in serious labor shortages. With many Mexicans on the move and the US in search of labor, both companies and the US government actively recruited Mexican laborers to the United States. These new migrants joined those who had lived in the US much longer and formed ethnic enclaves in places like Los Angeles. This migration, much of which was cyclical, meaning that workers would travel to the US for a season and then return to Mexico regularly, resulted in an increasing dependence on the part of the US on agriculture, on Mexican labor for agriculture. However, when the Great Depression fractured the American economy, these laborers became targets of repatriation campaigns. This era in the 1920s and 1930s, marked by nativism and eugenics, was also experiencing the worst economic depression in US history. As more Anglos found themselves without work, they began to exert pressure on city employers to only hire quote-unquote citizens for work. Of course, because of the Treaty of Guadalupe Hidalgo, which we just learned about, many of the ethnic Mexicans in the United States at the time were, in fact, legal citizens. However, ethnic background, rather than legal definitions of citizenship, became a shorthand to determine who was and was not worthy of citizenship. Take, for example, how Kenneth L. Roberts, a prominent nativist at the time, wrote about his observations of Los Angeles during a 1928 visit. Roberts wrote that one sees, quote, the endless streets crowded with shacks of illiterate, diseased, pauperized Mexicans taking no interest whatever in the community, living constantly on the ragged edge of starvation, bringing countless numbers of American citizens into the world with the reckless prodigality of rabbits, end quote. While he would make the case against birthright citizenship more forcefully elsewhere, here we can see the implicit argument. From Robert's perspective, Mexicans were illiterate, poor, and sexually deviant, and were abusing the gifts of citizenship by procreating so recklessly. While it's impossible to separate out the extent to which eugenic impulses drove or followed labor needs, the two forces entwined to create an intellectual argument for the removal of ethnic Mexicans from the US labor force during the Great Depression. During the repatriation era, somewhere between 500,000 and 1 million ethnic Mexicans were repatriated to Mexico, some of whom were US citizens. In scenes that eerily echo our contemporary moment, many workplaces faced raids and roundups of assumed undocumented immigrants, which also caught ethnic Mexicans who were citizens in the process. 20 years later, in 1942, as World War II sent hundreds of thousands of young US men abroad, the US government once again turned to Mexico to recruit agricultural labor to fill the gap. The binational program called the Bracero Program brought millions of Mexican men to work on short-term labor contracts to fill the national agricultural labor shortage. However, by 1951, there were concerns about the growing Mexican population in the Southwest. A commission on migratory labor commissioned by President Truman said of the problem, quote, the problem of illegal immigration, quote, the magnitude has reached entirely new levels in the past 7 years. In its newly achieved proportions, it is virtually an invasion. Many of those Mexican men who had been saviors of the agricultural industry in the Bracero program became targets of a new national program, Operation Wetback. Under Dwight Eisenhower, Operation Wetback sought to tackle the problem of, quote, illegal immigration. This operation, though short-lived, used military-style tactics to detain and deport ethnic Mexicans, both immigrants and in some cases U.S. citizens, from the United States. An INS report later indicated that the agency apprehended nearly 1.1 million individuals through Operation Wetback. The stories of the repatriation campaigns and Operation Wetback are only two stories in a long history of the recruitment and expulsion of Latino labor. While in this era, it is largely Mexican, as migration patterns change, this recruitment and expulsion cycle is repeated again and again throughout American history with other Latino groups. In my own work on the Latino South, I look at a more contemporary example of this cycle in Dalton, Georgia, the carpet capital of the world. Business leaders and politicians from across the political spectrum in the 1990s actively sought to recruit Latinos from Mexico, Cuba, and from within the United States to work in their rapidly expanding carpet manufacturing sector. However, by 2011, only 3 years after the global financial crisis of 2008, Georgia became home to HB 87, one of the harshest state-level anti-immigration laws in the country that sought to make life unlivable for undocumented immigrants. Again and again, we can see throughout American history that U.S. industry and capital have fought to recruit Latino labor without extending or defending the benefits of citizenship to many of those workers. Indeed, this most recent attack on birthright citizenship is simply another way to try and extract maximal labor out of immigrant workers without offering them or their families the rights of citizenship that should be afforded. For too long, the United States has sown what author Juan Gonzalez calls the harvest of empire without any accountability for what Lana Barber calls their imperial subjects. The violence of this cycle of recruitment and expulsion results again and again in families coming to settle in the U.S. to work the jobs for which they are actively recruited, only to see their jobs terminated, communities shattered, and families strewn apart. The contemporary acts on birthright citizenship echo earlier eras of anti-immigrant sentiment and only seek to further disenfranchise Latino communities. However, as many on the right use these policies to instill fear of demographic change by espousing the Great Replacement theory, those of us who know immigration history can be reminded that this is a part of a recurring and brutal cycle of recruitment and expulsion, and that this current era only extends that. The fear-mongering of politicians about Latinos and our presumed hyper-reproductivity and criminality are tied to a much longer history in the US. There is a quote that's often attributed to Mark Twain that history does not repeat itself, but it rhymes. If the gift of perspective and historical clarity can allow us to see past deportation campaigns for what they were, cruel efforts to manage anxiety about demographic change in the economy through racialized scapegoating, then we must commit to interrupting those practices in our present moment. Thank you so much for letting me be here today.
Thanks to all four of you for those really powerful comments and for kicking off this conversation. For those of you who are watching, we're taking questions in the Q&A under the Q&A button if you want to add your questions to this. But I have a few just to start us off. A number of you have touched on the contemporary moment and how it resonates with the history that we're discussing. But I wonder if we could just start by, if each of you want to say a few words about how you see this history resonating today. And let's just go in the same order that we went with the speakers. So Anna, would you like to begin?
Could you repeat the question again? I was trying to read the chat at the same
Oh,
time.
sorry. Yeah, we're asking you to multitask. I think a number of you have spoken on the contemporary relevance of this history, but I wonder if you could just sort of briefly state what you see the most important contemporary takeaways of what we've discussed so far.
Okay, thank you. From my presentation, the historic, like Cecilia's presentation about Latinos not having citizenship or having their citizenship questioned, like Native Americans who have a different relationship to the polity, the research in African American history of the United States. I mean, I only talked about one aspect of free Black people not having a clear citizenship, and it was that they lacked the right of mobility, of interstate and international travel, and that they couldn't live and set roots where they wanted. That's just one kind of discrimination because of the lack of citizenship. There were many more about labor rights, about rights to equal protection if they're charged as for criminal, being charged for a crime, all sorts of things. So I would just remind everyone to look at the past and say, okay, when people didn't have formal citizenship, what bad things happened to them and what was the state allowed to do against them? Thank you.
Yeah,
Thanks, Anna.
that was great, Anna. Thank you for that. I guess I would just say very quickly that the cultural frameworks that we historically have attached to citizenship, even before it was codified, have, in the same way as the thin blue line flag, placed citizens in one category and other groups of people in another, even when they are technically citizens. And Mae Nai's concept of the alien citizen gets at this really beautifully, I think. But those categories who fall in the bottom, it's criminals in the thin blue line flag, citizens and criminals. But it can be slaves, it can be savages, it can be lots of epithets that capture either forms of dependence or forms of violence, and we are in the middle of a kind of recalibration of that in a way that I find quite terrifying.
Well, one thing to notice is that the rates of immigration were very high around the turn of the 20th century, when we start seeing this move toward exclusion and quotas and so on. And they're high today. So if you look at percentage foreign born, it is higher than it has been in quite a while. I think this is not irrelevant to why we're getting some of the backlash that we're getting. I think we also get some of it because of the fear of that we may not be a majority white nation much longer. But this question, and we're certainly going through a period of Mexican bashing, just as we went through a period of Asian bashing, that somehow they're immoral, they're dangers to the nation. They can't be assimilated. All this kind of stuff. They're draining resources. One of the important questions, it seems to me, that Wong Kim-ark tried, I mean, Wong Kim-ark's settlement was, the court is settling this question because the 14th Amendment says what it says. But right now, with the president trying by executive order to change birthright citizenship, the question arises, if we don't like it, who gets to change it? And is something short of a constitutional amendment the way to do it? And it seems that if the court is right in Wong Kim-ark, then it's a constitutional amendment process. Even if the court isn't completely right, it's clearly not the position of the executive to change it.
Yeah, I feel like I'm multitasking by learning from you all, and so I'm trying to gather my thoughts as well. I think that, when I think about what's happening in this moment, I think that everyone on this panel has very eloquently talked about the kind of the legal stakes of this, the legal precedents of this, and the risks involved in sort of the judiciary and the executive branches. You know, what I think about, and this is just my own sort of bias, is about this question of sort of social citizenship, right? The gap between what we are legally entitled to and what we in fact experience. And to me, what is particularly scary in this moment is how much that gap is widening, right? I mean, when I think about the most recent Supreme Court case around racial profiling and the fact that what was at one time seen as extreme in Arizona's SB 1070 law has now just become law of the land, right? And so this idea that you could pull someone over for being presumed illegal, right, which we can all assume means Latino, you know, that is that's very concerning to me, right? That's very concerning to me about how much that gap is growing, about what actual protections we have as citizens seem to also be shrinking at the time that they're also trying to shrink that category of who gets to be a citizen, and what it means to be a citizen also seems to be increasingly compromised under a growing authoritarian regime. And so, you know, these are some of the things that it brings to my mind in this contemporary moment.
Yeah, thanks for you all. I wanted to pick up actually on something that Cecilia has brought really focused, I think, our attention on, and that is that ambiguity of citizenship and the sort of space between legal and social citizenship. And I think we can see that, you know, very clearly, of course, in the deportations and the where on one hand, non-citizens are deprived of rights and due process that presumably would apply to them whether they were citizens or not. But then you have citizens because of their race deprived of protections that should come with their citizenship. So in all of those cases, and presumably today with mass deportations, we always see large, significant numbers of citizens deported, essentially on racial grounds. I think, you know, Anna referred to the pre-14th Amendment era when African Americans, when free Black people who were even considered sort of legal citizens in some states had to carry passes, had to prove their citizenship, were subject to deportation and unable to move to other states. And also this, again, these sort of ambiguities. So I wonder if I mean, on one hand, one could look at this and say, well, maybe birthright citizenship doesn't matter. You know, I mean, whether you have citizenship or not, if you are denied those rights, you know, you're denied those rights. And I wonder, what does this ambiguity tell us about the 14th Amendment and about birthright citizenship? And I guess I would throw that to anybody on the panel who wants to take that question.
I'll just jump in and say, I think what it teaches us is that we tend to think of citizenship as on or off, yes or no, black or white. But in fact, its history is saturated with ambiguity, contradiction, paradox, and citizenship is better understood, less well understood as black letter law than as a terrain of struggle. And it is an important mechanism for claiming and achieving certain kinds of rights, but it is in no way a guarantee of those. And I think it's helpful. My colleague Marla Ramirez is just publishing a book called Banished Citizens, which says deportation is the wrong way to frame what happens to Mexican American U.S. citizens in the 1930s. They're banished. And there are many examples of this kind of across our history. And I think if we are willing to pay attention to them, we can see that it's constantly been this kind of a struggle.
Go ahead, Carol.
I think that it's quite clear that citizenship is not, it is a continuum at best. And that many people are considered, at Wong Kim Ark's time, they were considered accidental citizens. They were surely discriminated against, although there was one remarkable Supreme Court case that did say the 14th Amendment protected Chinese Americans, but it was one of only a very few. So many people are discriminated against and assumed to be not citizens. So the profiling, the getting locked up, all that stuff. indignities that people experience every day because they are presumed not to be citizens, either because of an accent, a name, where they live, etc. And so, yes, citizenship didn't even help Wong Kim-ark. There was a copy of the court decision in his file in 1913, so that they wouldn't have trouble getting back in, but they're still harassed.
Yeah, I think I'd love to just add just a little bit to what Steve was saying too. I love this idea of citizenship as a kind of terrain of struggle, right? When we think about, I mean, I think that looking at in African American history, we have a lot of great examples of this too, right? We see, Brown v. Board brings down legal segregation in educational institutions, and yet that is a terrain that has to be fought over and over again, even as segregation becomes sort of illegal in the sort of rule of law. And so I think. African American history, contemporary, modern African American history has so much to teach us about the gap again between legal and social citizenship, and how it is both about the kinds of fights that we have to have through legislation, through these cases, but it's also about struggle and kind of pushing back against the social pressures towards discrimination, towards racism, and things like that. And so I just really found that a very compelling framing of it as a terrain of struggle.
Thanks. So we have a couple questions, really interesting questions in the Q&A. One is just about the question of international adoption, and I don't know if anybody wants to try to address this, but the people who are born outside the United States and then adopted by American citizens have the right to become, quote, citizens of the U.S. by birth, and that people also who are born outside the United States to U.S. citizens have a similar right. And I guess I wonder if anybody wants to touch on this, and does this tell us something about this broader meaning of citizenship and the 14th Amendment?
All I can say is I've had several people contact me with the question, am I in trouble? I was adopted at birth. I said, no, you're not in trouble. But you're right. The questioner is right that it's not widely talked about. As far as I know, there should be no difficulty for someone in that position.
I'm not an expert on the adoption and the citizenship. The person you need to contact is Arissa O, the historian. Her last name is O.H., and she's an immigration historian. She does research on Korean adoptees, so she would be the person who could answer that question.
Yeah, thanks to both of you. So what are the arguments, what are the sort of the strongest arguments constitutionally for denying birthright citizenship on the basis of the 14th Amendment? So the answer, the person who asked this suggests that perhaps there aren't any that you would consider strong, but what are those who do advocate for this? What do they put forward?
The one I fear, therefore the one I think is probably the strongest, is, okay, Wong Kim-ark was a fine decision. His parents were here legally. Wong Kim-ark didn't have anything to say about the children of people who are here without the nation's permission. And I could imagine this court listening to that kind of argument, if and when it ever gets to that point, because the court could say, well, Congress in the Immigration and Nationality Act of 1952 basically adopts the language of the 14th Amendment, same thing as Wong Kim-ark, and we're not going to reach the constitutional issue.
the the difficulty is that the idea of illegal immigration, just as people have said already on this panel today, simply didn't exist in the moment of the framing of the 14th Amendment. It wasn't, that was not the issue, that was not the question. And so the court, I fear, may reach for analogies, and I hope, I mean, the ones I've seen the federal government's lawyers make are hideous and ridiculous, but may reach for analogies that are more subtle and sophisticated than the ones in the responses to the in the defense of the EO. And the parade of horribles that follows in terms of litigating, legislating, and enforcing questions of human status on a scale we have never contemplated before is just kind of unthinkable to me.
I'm also afraid that because the 1980s case Plyler versus Doe about children of undocumented immigrants having access to schooling in Texas, because it rests on wonky mark, and because we've already seen the Justice Department lean on Texas to withdraw allowing undocumented immigrants to have in-state tuition breaks, that's exactly where we're going next. That children will not have access, free access to public schooling in the United States before too long.
I agree that if the court were to overrule Wong Kim Ark, it would be some sort of argument about undocumented, unauthorized people, which all the panelists have established that was not the concern, that the policy concern or the political concern of the people who wrote the 14th Amendment. But let's be clear, it's not true that there was no such thing as an unauthorized person in the US. There were. The Congress and the president passed an act in 1808 that banned the international slave trade. Anyone found in the US after that, and there were a couple hundred people who were smuggled in illegally, those are unauthorized people. They talked about that, they knew about that. During the debates of the 14th Amendment, the people in Congress said, okay, yes, we know about them. We're not, but we're more worried about if you don't provide birthright citizenship, what about all those Italians and Irish and white ethnic immigrants who are born to those immigrants who are the children of them? What's going to happen to them? So there were discussions of unauthorized illegal people, and they knew it, and they said, yeah, those people are covered as well, definitely covered by birthright citizenship. But I don't think the United States Supreme Court is very careful with their history. They like to do law office history. Somebody asked in the questions whether there's a historian's brief on birthright citizenship. Historians Kate Mazer and Martha Jones, two of the best in the business on that question, have written a brief with the Brennan Center. Whether the Supreme Court pays attention or reads it, that is a different issue.
I think this gets well at a question, another question in the chat, just about the ways in which sort of public opinion is shaped about these issues, and the fact that I think, I mean, we're clearly in a moment of very rapid change about ideas about citizenship and belonging, and we've also clearly seen moments like this before. Clearly the period in which of Chinese exclusion, the period of the deportations, and I wonder if any of you, if you have thoughts about how we understand the sort of ebbs and flows of these opinions, and And how might these be changed? The question was, it seems the idea of who should be citizens is affected by the opinions and feelings of people throughout the country at any time period. Do you see any progress in the opinions or feelings of America? How can we help to change minds and hearts?
Okay. I've taken a little look at public opinion on some of the Trump immigration and birthright citizenship executive orders. Surprising to me, the majority of Americans do not want to see a change in birthright citizenship. It may be as an artifact of the way the question is asked, but they are far more supportive of restricting immigration than they are of changing birthright citizenship. So I don't think Trump has convinced them that we need to take this drastic step.
Can I just follow up, Carol? Did you say it was surprising to you that?
Slightly.
Why?
Well, because he's been on this theme since 2016, 2017.
Yeah.
I think there's no support for birth tourism, by the way, but this does not require a constitutional amendment. You know, the State Department already has a regulation in place that could take care of that.
Can you just briefly explain birth tourism?
Oh, sure. There is a practice of tour operators offering package tours to women who were, say, 7 months pregnant, 6 months pregnant, to come to the United States to have their babies. And they all run to Disneyland and they do other kinds of touristy things. But their babies are born here and they get US citizenship. It is often Chinese women who do this. It's a very expensive thing for them to do. But it also has some logic that I think many people don't understand, and that it allows the person who gets US citizenship to move between cities or from country to city in China, whereas their parents don't have that freedom of mobility. They get a different kind of university entrance exam, and there are other kinds of benefits. So they're not necessarily planning on coming here. Some Russians do this, and there's some Turkish people, and those are the three major groups that participate in this activity.
Thanks.
So
we have a few minutes, with just a minute or so left. If anybody would like to make a final comment on any of these questions.
I just wanted to take a crack at the Supreme Court. I don't care. I mean, it's a very strange thing for a constitutional scholar to say, but I'm going to say it. I don't care if the Supreme Court strikes down Wong Kim Ark and strikes down birthright citizenship. It's not that I don't care about the results. They will have gotten it wrong. And in US history, the Constitution has never meant what the elites and what the Supreme Court said it means. It also means what we the people say it means. So if the Supreme Court strikes down birthright citizenship, they are wrong, and the court needs reform.
Steve or Cecilia, a parting comment? Try to top that.
Yeah, I found that very compelling. So I'll what she said.
Yes. That they're wrong is also us over a waterfall.
Well, thank you all four of you for this discussion, and to the IHRC for sponsoring this discussion, and to the audience for joining us this evening. It's been a really fascinating and I think important discussion at this moment.
Thank you.